Welcome to 5 at 5 with Stone Law Offices. I'm attorney Brendan Bybee with 5 minutes on trust schedules and why they're important. So when you set up a trust, a lot of times, depending on where you go, certainly if you come to our office, you'll get at the end of that trust, there'll be perhaps a schedule of assets. In many cases, it might just say $10, and basically it's signifying property that's supposed to be in the trust, because a foundational purpose of a trust is to, or need for a trust is that it has to have property in order to exist. Without property, there is no trust. So a lot of times there's this nominal recitation of trust property in this schedule or exhibit to the trust. In many cases, it's called a Schedule A. And regardless of whether it's specifically titled that way, sometimes attorneys, if you're around attorneys, they may talk about it as being the Schedule A. Now, trust schedules, they don't, listing property on a trust schedule does not make it, does not change formal title to it. So if you have real estate, whether that's in your home state, whether you're here in Nevada or whether you're elsewhere, have a vacation home in another state there, you might list all that property on your trust schedule, okay? And so it's essentially a list of assets. And it's certainly very handy for a successor trustee who comes in and says, well, what am I responsible for? And so obviously it's very helpful there. They've got an inventory of the assets of the trust, and they at least have a starting place for knowing what their responsibility is. Technically, formal title, a trust owns only what's formally titled to it. So your house, if you haven't changed title, if the title is in your name or in yours and your spouse's name, and it says joint tenants with right of survivorship, then it's not owned by the trust. If you've got a bank account and it's got your names on it, then it's not owned by the trust, unless it says, of course, your name is trustee. So generally speaking, if formal title hasn't been transferred, then it's technically not owned by the trust. However, under Nevada law, one way to make a trust or to bring property into a trust is by listing it on a schedule of assets for the trust. It's a statutory provision, and it says if that list, if you make a list of assets or schedule of assets and you signed that list, or you've referred to that list in a trust document that's been signed, then that property is deemed to be property of the trust. Now, this is something that we've done in Nevada for some time. It's becomes very useful in cases where perhaps some property hasn't been transferred before the person died, and now if the property has to go through a probate, then we have a probate proceeding that has to be done while a trust administration is ongoing, waiting for the probate assets to then be added to the trust and be distributed out. Obviously, since we create trust primarily to avoid having to do a probate, this is not efficient and not ideal. So there was a case in California called the Estate of Hegstad. That the principle of that case has essentially been codified in California law as well as in Nevada law, but the principle has been applied in Nevada and California. And I'm not sure what other states, not every state does this, and so that's also important to remember. But the idea is if you create a trust and you own a certain asset and you make a declaration that asset, you hold that asset now as a trustee, then that property is then going to be deemed to be trust property. And if you die before having transferred it, then the trustee can petition the court and say, court, this property is listed on the trust as a trust asset in this schedule. The grantor of the trust, the person who created this trust, has declared it to be trust property, and therefore we ask the court to recognize it as trust property and transfer that property to the trust without having to go through a formal probate. So this can work with real estate. It can work with any assets really that are listed there. And so having an up-to-date schedule of assets, a list of assets for the trust, can be very beneficial in this way, in that even when some funding hasn't been done, assets haven't been completely aligned with your estate plan to make sure that everything's in the trust already, that they can get into the trust, perhaps on a single petition to the court without having to go through a probate and all of the process that goes with that. The caveat with this is Property, real estate in particular, is only subject to the courts of the state where that property is located. This is all presuming you're a Nevada resident. If you're dealing with Nevada property, then you can proceed in a Nevada court with that schedule of assets and move the property over. If, however, you have that vacation home in Utah, California, or somewhere else, that process will not be available to you here. If it's in California where they do recognize that, you can proceed there, but it'll be another court petition in California. You'll have a court petition in Nevada for any property here. If your property is in Utah or Colorado or one of those other states, then you're really out of luck and you'll have to do a probate there. So again, the primary recommendation is that you get all of your property formally titled into your trust as soon as possible after you've created the trust. But also to know that if you keep an up-to-date schedule of trust assets, in many cases, as long as you can bring it in within the jurisdiction of the state courts of Nevada, that you can transfer that property to the trust, regardless of the formal title, without having to go through a probate process. If you have property that you need funded to your trust, if you haven't already taken finished your homework essentially on your estate planning and moved your assets into your trust, we can assist with that, and we can help move bank accounts and whatever other assets you might have. But remember, it is important, regardless of having that schedule. Ideally, don't rely on the schedule. Ideally, have everything put into the trust now as soon as possible. And if you need help with that, we're happy to do so.